The workers' compensation law has a discrimination provision. The discrimination provision says that the employer cannot terminate you for filing a claim or participating in a workers' compensation claim. However, the workers' compensation law does not protect your job. If the employer takes the position that they need to fill your job in order to continue their business, they're entitled to do that under the workers' compensation law. However, there are other provisions of law and there are other provisions of contracts and employment policies that may give you greater rights. For instance, the federal Fmla Act requires an employer who has more than 50 employees to hold your position for at least 12 weeks if you're disabled from work. If you're in the public sector in New York State, you're probably covered under the civil service law, and the civil service law requires the employer to hold your job for up to 1 year. In many civil service jobs in New York, if you're injured as the result of an assault, the employer has to hold your job for up to 2 years. In addition, there are other benefits that are often payable if the injury is the result of an assault. One helpful thing to know is that if you believe that your injury was the result of an assault, make sure that you indicate that clearly on your workers' compensation paperwork and on your accident report to the employer. Because later on, if it's not written down that it was an assault, they may deny you the extra year of job protection, or they may deny extra and other benefits that might be available to you if the injury had been reported as an assault in the first place.